And thank you, Jade, for your call. Of course, again, we invite our viewers to continue to call. And in fact, we do have somebody else on the line. Next is Marion. Marion, go ahead.
Good evening. Thank you for getting me on the line. I believe that my question will be a little bit too difficult for Mr. Lawyer. I got a judgment on motion without notice. My pleading was struck. Everything in judgment with full knowledge of the judge, full knowledge of a lawyer, or 90% of what I had. That example, when Revenue Canada wasn't there, I admitted it in my paper. The valuation of my pension was 3 times higher. My ex-wife claimed that I agree, what she removed everything from the house, that I agree about it. It never happened.
So
I'm fighting it 12 years, and I am saying, is it possible to get on motion without notice, without, certainly you know that I didn't know about it, spousal support, she got it, without any elaboration on how much she is making, how much I am making or so. She got spousal support, lump sum payment, $35,000.
okay.
It is $600 a month out of my pension.
So your question is whether
my question.
Marion, sorry, I have to interrupt there. I just want to make sure that we get your question right and we're able to help you accurately. Marion,
Yeah, okay.
is your question, how is it that she was able to claim that spousal support without the evidence?
Yes.
Okay.
First question. Second question. Lawyer was saying that self-represented people, that it's too hard and complex. I believe I know law quite well. I am saying, I am complaining 12 years to the court, to the Law Society of Upper Canada or so, that everything is affidavit was falsified.
Everything in her affidavit.
Nobody,
so, Marion, sorry,
Marion.
Marion, everything in your ex-wife's affidavit was falsified? Is that okay?
Fraud. The number, and knowingly, they knew that those numbers are fraud.
Well, Marion, what we can do then is perhaps answer your question with respect to, perhaps there are, I think, two issues or 2 strong questions here. How is it that, or is it possible for someone to claim spousal support a certain amount without there being any evidence? And what happens if you lie in an affidavit? So we'll get those questions out of the way for you, Marion.
I have some questions for you, Marion, because you said your pleadings were struck. And for viewers, that means that Marion was originally before the court. And if I'm right, a judge decided to, in essence, say you can't participate anymore. Usually that happens. Let me finish. Usually that happens because you breached a court order. Did they bring a motion on notice to you where your pleadings were struck by a judge?
I can hear you.
Was the reason your pleadings were struck, when they did that, did they bring a motion before a judge saying that you didn't comply with a court order?
Court order was that I was supposed to pay for, I was asking from my employer giving valuation, a rough number for valuation of my pension. But because my case was complicated, I showed letter that they were not able to do it. They say that if I will not pay to them $2,100, what I didn't have this time, I was divorced, my wife completely deleted all money from any account or so, and I told judge about it, that if I will not pay it within 21 days, then my pleading is struck, and they can go with motion without notice. But
okay, so that answers the question.
I will tell something. Motion without notice is law. Every motion, doesn't matter if pleading is struck or not, can go back to the court within 14 days or 15 days or whatever. Every motion.
So were you saying that you...
What I have done.
Marion, you're going to have to let us try to figure this out, just because I know that's a very complex scenario. But let Andrew sort of explain.
My question is that how is it possible that any lawyer can use fraud, falsified documents in the court, and nothing happened to them? That is my question.
Okay, thank you.
Okay, first of all, I would find it surprising that that any lawyer would use falsified documents. A lawyer may have been given a document by his or her client. Whether his or her client has falsified the document is another story. What you would need to do, Marion, is if your pleadings were struck because you did not comply with a court order, irrespective of whether you agree with what the judge did or the judge didn't do, the problem is a judge made an order. And when a judge makes an order, it has to be complied with unless you appeal that order and you're successful on that appeal. So the problem you face is your pleadings were struck, and now the question is, really, what do you do if their affidavit, and I believe was probably for an uncontested trial, yielded an order that they're happy with and you're not happy with? I can't quote you the cases, but there's a body of case law that says when you go to court in an uncontested trial, they have to come forward and make sure they're telling the truth on all the points to the best of their ability. And if the reason they didn't give all the information was because they were guessing and you didn't give them documents or information, that may be one thing. But if they knew they were telling false information to the court, that's what can open the door for you to bring a motion to set aside that existing order. But if you're successful on it, it doesn't necessarily mean you get to come back into the next time they have an uncontested trial. It just means that you've put on the record that what they said was wrong. A judge could set aside that order and give them another shot.
Or they can refuse to set aside the order as well.
Absolutely.
Yeah.
And you're going to have to prove that what you're saying is correct and what they're saying is incorrect.
And what type of evidence would Marion have to gather in order to disprove that or dispute the evidence that was given originally?
Well, the challenge I have with that question is I don't know what evidence it was. I don't know the details of the evidence.
An example.
An example would be if one spouse would say, well, I'll give it as an example, a husband, since marriage, is that my husband was making $250,000 a year in, say, 2011 when we were married. And Marion, as an example, could produce a copy of the wife's tax return, and on the wife's tax return, it has a spot where she has to say what her spouse made. And if she had put down in 2011, my spouse made $50,000 a year, there's a big disconnect there. And would that give rise to it? It certainly, if I was the judge, I'd be thinking there's a problem here, and I'd want to hear what the explanation is from the wife, why there's such a big disconnect. That would be an example of something I could see applying.
Now, Marion, does that answer your question? I want to make.
Not really. It doesn't work this way. I claim that I do owe Revenue Canada $10,000. And she didn't put it in. Judge knew about it. I went to Appeal Court of Ontario, Divisional Court. Everybody knew. Example. There is one example. There is the slowest part.
Sorry. So you owed money to the CRA, and then what happened? You tried to.
Nothing. They say that first order was right.
Okay, so Marion.
Saying that first order was right.
So Marion, I think the options that Andrew was saying still stand in that case as well, or is it a sort of different scenario?
If you've did you appeal the order to strike your pleadings, or did you appeal the final order of the court?
I was going around.
So,
they did mistake.
So Marion,
they took
how about
motion,
this? Marion?
In this motion, I went to Court of Appeal of Ontario, but Divisional Court, then Court of Appeal for Ontario.
Okay, so Marion, I'm going to have to stop you there. Marion, we're going to have to stop you there. We do have so many callers to get to. So perhaps Andrew can wrap this up. And unfortunately, Marion, we're going to have to move on to the next caller. So essentially, the difference that you were trying to point out there?
Is if you went to the Court of Appeal and you were unsuccessful in setting aside the order for striking your pleadings, then your pleadings got struck. If you went to the Court of Appeal to deal with the final order and you lost there, that's the end of the case. You're done.
You're done.
You're done completely. If it's on the pleadings, you could at least still try and bring that motion to set aside that final order on the grounds that I said. But I will caution you, it's a real uphill battle, because when your pleadings have been struck, the courts do that in the rarest of circumstance. That sets out optics for any judge you deal with that puts you in a very negative light in front of a judge.
Thank you very much so, Marion. I know it's a complicated case, but it goes to show how emotional and difficult a lot of these cases can be, and self-representation sometimes is not the easiest thing to do. It gets complicated.
Gets complicated, and you see the result. The pleadings were struck,
Yeah.
and he's totally unsatisfied
Yeah.
with his result.
Yep. And well, we're gonna have to move on to Edith. Edith.